All right. Hi.
Hi, how are you?
Good, thanks. How are you?
Good, good.
Okay, good, good. So we're just got a couple people on. All right, we've got some more joining. All right, we got Prince on and Mara from Munster. Welcome. Um, so I guess we can get started. We are doing celebrity estates. So we're going to be talking about today. We're going to be talking about Heath Ledger, the actor, and Michael Jackson. So we get to learn about what they did right or wrong on their estate and what we can learn from it so we can make sure that our estate plans don't do those same things, or if they're done right, to do them the same way. So um, Christina, do you want to start by talking about Heath Ledger and giving the background?
Sure. So, as we most of us know, Heath passed away unexpectedly from what was reported as an overdose. I believe he was about 28 years old. And while he had a will, he had done it a couple years earlier, about 3 years earlier. So he took the steps at 25 because he knew the importance of having a will. What he failed to do was update his will after he had his child. So he had a daughter. She was 2 when he passed away, but he never updated his will. So his will provided that everything was left to his mom and his sisters, and left no provision for his minor child and his only child, or so they thought to be his only child. Um,
Or his girlfriend at the time, the mother of the children.
Correct.
Hmm.
So that shows the importance that while you may have a will and you may have done it, a year or two before, I always tell my clients that they need to come back to see me when any kind of life-changing event, so marriage, divorce, losing a parent, gaining a parent, having a child, any of those things, a child attaining the age of majority, they should come back in and review their estate plan. Even if they don't have a life-changing event, every 3 to 5 years, everyone should look at their will, their trust, their healthcare proxy, their power of attorney, and make sure it's all up to date with what they want. Sometimes, our friendship ends or we get into little, you know, mm, discussions with family members and decide we're not on the same page anymore. So it's always important to keep looking at those documents.
Right, yeah. And sometimes finances change, right? So you might change like how you want to distribute it, or you might inherit money. So any of those changes really warrant like reconsidering your estate plan. And I'm sure Heath Ledger did not think at 28 he was going to die. So, and I'm in my 40s now. I have friends who have kids that are now 28. So maybe you're doing the right thing, but you have friends who have kids, or you have kids watching that are around that age. So once you turn 18, you really need to do an estate plan, believe it or not. Um, and so, especially if you're in your early 20s, that's not too young to do an estate plan.
And a lot of times I get Leslie with me and my friends as they say, oh, well, I don't really have anything. What do I have? Or I only have a house. Or I only have joint bank accounts. And, I say to them, you have children, you have minors. That's the most important thing, really, aside from your properties, making provisions for them. And maybe it would be a good way for you to seg into the Michael
Michael
Jackson.
Jackson. Yeah, well, we can come back to Heath Ledger if people have questions, or there's might be a few things I want to bring up. But yeah, thank you. So the segue into Michael Jackson is he did do a will when he had his children, and he did name guardians in his will for who he would want to raise those children if he passed away. And as we know, he passed away with the 3 children were minors. I think they were 11, 7 and something else, 9 maybe, the 3 kids. So they definitely needed guardians at that age. Now, of course, Michael Jackson was the sole parent. He was raising those 3 children himself. So he had an ex-wife who was the birth mother of the 2 children, but we don't know for sure if she actually gave up custody of the children. And then he had the third child, Prince Jr., with a presumably a surrogate. And so we don't know what her relationship was with the child, but assuming he hadn't done a will, what would have happened to those children when the mothers try to come and claim those children? So luckily he did a will. He named his mother, the grandmother, the guardian, and she was successfully appointed. So that is at least a good story, a successful story that we take our stories from the trial and errors book, which is mostly mistakes that people made, but that at least was a good one that we can share. Um, and then next month when we meet, Christina said we are going to talk about what Michael did wrong with his trust. But at least today we've shared his will story. Anything you want to add on the Michael Jackson story?
No, so I think you said it all there. You know, that's the most important is having a guardianship provision in your will as to who you want to be the guardian of your children. When you fail to put that in there, or if you pass it without a will, and you know, sometimes, let's say both parents pass away, or the last parent passes away, now you have people fighting to be the guardian. Is it the grandparents fighting? Is it, you know, aunts and uncles fighting? No, I should have them. No, you know, what happens if, you know, the decedent's sister says, you know, the kid should come live with me, but she lives in another state? Is that what you would want for your kids? So having that provision in there specifying who you want to be appointed is so important. You know, alternatively is you have grandparents fighting and the court could turn around and say, you know what, I'm not appointing either of you. We're going to appoint so-and-so, where we're going to have an independent guardian, a court appointed who knows nothing about the child. So
Oh
those
my
are
God,
really,
nightmare.
real big deals, you know, when it comes to having minors.
Yeah, totally. Thank you for bringing that up. Um, Now, going back to Heath Ledger, the story goes on that he did do like a life insurance policy and he did name his daughter on the life insurance policy. So that's interesting because he didn't update his will, but he did do the life insurance policy. So it raised the question of, did he really want all the money to stay with his parents? And we'll never know, right? Because he didn't actually update his will. Or did he just not get around to it? Now, he died in California, I think, or where,
Mm,
do you remember where he died?
I believe he died in New York. I'm
Okay,
not
but
I'm not sure where he died, but they did probate it in New York.
right. But then
They
they also said they probated it in Australia.
Right, because he probably had property there, and that's where he was from. So they also had to probate it there. But just going back for a second, what you said about the life insurance, you know, they're two different things. So it was probably easier for him to have a life insurance agent who he could call up or come meet him on set or meet him anywhere to sign something quick, saying, okay, here's a life insurance policy named so and so. Whereas with a will, especially in New York, there's certain procedures that need to take effect in order for it to be signed properly and witnessed correctly. So it would take a lot more to have an attorney redraw up the will, have two witnesses present, sign it, notarize it, do all of these things. So people sometimes, you know, say, oh, I'll get to it later and never do. Excuse me.
Right. Yeah, it's sad. Yeah. Um, so assuming he was in New York, and this might be something you're familiar with, we talked about what's a pre-terminated heir law. So if now luckily Heath Ledger's estate was resolved amicably. His parents gave the money to the daughter, so there wasn't an actual court litigation dispute. But there is something called a law that protects children if they're born after a will. So have you dealt with that, and what have you seen with that? Because it seems like it's not a full distribution.
So luckily, I've never actually had to deal with that. Um, I've never had a client who did not or didn't not mention it. So I'm fortunate enough that my clients come see me before tragedy strikes. So I have not dealt with it, but there is an EPTL section that does talk with it, and it goes really in depth. It depends on if the decedent had children already, and if they already named those certain children in their will and just failed to name the afterborn child. And then there's portions and percentages. So and there's even a part of the EPTL that says that, you know, if you name some children and not all, then the children that are not named may not get anything. So it really depends on situation by situation, circumstance by circumstance.
Yeah. So, yeah, luckily this was resolved. If anybody's watching this, and you have minor children, we want to emphasize making sure that you name a guardian in the will, because that's sometimes the only way your wishes will be known for who would raise your children after you pass away. Um, and it can also nominate sort of like an exclusion. So I had a client come to me because the father of the child was not ever around. He was never present, and she did not want to die and have the father then step up and try to raise the child after all these years. So that was something we also could take care of legally, is create I forget what I called it now, but a document to exclude him from, to let the court know that he, by, the decedent absolutely did not want him to come in and raise the child.
Yes, I had something similar where the mother did not have custody of the children, barely saw them. So we had to make sure that we planned for the event that the father passed away to make sure that the mother wouldn't come back or try to come back. Um, so again, it's really important to have these wills to make sure that the guardian is designated. Had this father not have that provision and he passed away, there's the possibility that the mother would try to get custody of them, or not even get custody, more of guardianship, and that would, put her in charge of their assets and making decisions for them, where they go to school, what activities they do, things that she was never involved in.
Right, and that's a really good point too. So just to distinguish, we have guardianship over the child or guardianship over their assets. So for example, in Heath Ledger's example, I'm sure the mother was still the custodial parent. She's still alive. She's still the guardian, but he may have not have wanted her to control the money, right? Maybe she was a great mom, but she didn't, she had a hole in her pocket and all the money drifted. So he could also have named someone to be financially responsible for the daughter, while not disturbing any of the rights of the mother. So I guess that's it on that.